So I'd like to turn the program over at this point to Jim Austin, who again is with the New York State Public Service Commission.
Good afternoon, everyone. As Sharon just said, my name is Jim Austin. I'm with the Department of Public Service. I'm the Deputy Director of the Office of Energy Efficiency and Environment. And within, we're having a little problem here. And within that office, we have a section called Environmental Certification and Compliance. That office is responsible for siting of electric transmission and natural gas transmission pipelines. And with the enactment of the new Article 10 law, we're also responsible for siting of power plants. I've been asked to speak about Article 7 of the Public Service Law, which is the law that the legislature did to create linear projects. A power plant is on a 5-acre site. A well is on an individual site. Transmission lines tend to be what we call linear projects. They go across multiple towns, multiple counties, sometimes multiple states and countries. As a result of that, citing them and certifying them before Article 7 involved countless municipalities, local governments, county governments, state governments all had to issue approvals. As a result of that, the legislature enacted Article 7 of the Public Service Law in 1970, the idea that it would be one-stop permitting for the entire project. And that includes environmental, all the permits, state and local permits that would be required for a project. When they did this, they had a couple things in mind. The legislature, first thing was they wanted to minimize environmental impacts, identify and minimize them. They wanted to make sure that there was a forum for public input, local input. I had my PowerPoint, but, oh, sorry, but it didn't make it. Where am I? Also, citizens and municipalities, public interest groups, other state agencies. One thing I do want to make clear is Article 7 is exempt from what's called the State Environmental Quality Review Act, what we call SEQR. SEQR is a law that says anytime a state or a local government issues a permit or approval, that project, whatever it is they're permitting or approving, has to go through an environmental review. The state law, Article 7, specifically exempts pipeline and electric transmission projects from SEQR. Having said that, it's almost exactly the same process. In fact, in many cases, it's more rigorous because SEQR allows something called the Generic Environmental Impact Statement, or GEIS. And with the Generic Environmental Impact Statement, if you have a bunch of projects that are all going to be the same, you do SEQR once, and that SEQR covers all those subsequent projects. With Article 7, every review is a case-by-case review. So for every single pipeline, we have to do a full environmental review for that. And as I said, the review is substantially similar once you get into it. I talked about this before, but the purpose of Article 7 was to minimize the environmental impacts, such as forest clearing, stream wetland habitat impacts, land use conflicts, such as disturbance of agricultural land, visual impacts on cultural or historic resources, also quality of life impacts, such as construction disturbances, noise, traffic, things like that, and also provide a forum for resolution of those issues. What's covered by Article 7? A few minutes ago, Sharon just put up a list of different kinds of pipelines, gathering, transmission, distribution, and I noticed that her list doesn't really comply with ours. We have different ones. Article 7 is anything that is above 125 pounds per square inch of pressure, anything that is 1,000 feet or longer, and that's all. Anything that meets those two things is subject to Article 7 of the Public Service Law. When they first passed Article 7, it was one size fit all. So a 6-inch, 125-pound line that ran 1,100 feet went through the exact same process as a 1,400-pound, 48-inch pipe that crossed the entire state. And that situation was in place until 1981, when the legislature complained that the Public Service Commission was taking too long to do the smaller projects. We were applying the full process, as I said, one size fits all. So in 1981, they modified the process and created basically what we call a small, a medium, and a large pipeline project. And those are in sections 121A of the Public Service Law. The smallest one is the 121A2 of the Public Service Law, and that's greater than 125 PSI, greater than 1,000 feet and less than 6 inches in diameter. So that's the small one. The medium one is either greater than 1,000 feet and less than 10 miles, or greater than 6 inches. Either of those two things trips you into the middle category, and that's 121A3 of the Public Service Law. The third one is the big one, that's 122 of the service law, and that's anything greater than 10 miles. So the small ones were roughly equivalent to what the Sharon referred to as gathering lines, although there are gathering and what's called midstream lines that are in that section. And I also have to say there's an awful lot of gathering lines that aren't subject to Article 7 because they're smaller than those two initial thresholds. They're either smaller than 1,000 feet, or more frequently the case, they come in under 125 pounds per square inch. And I don't think I have to tell this room how many pipelines we see that come in at 124 pounds per square inch. There's quite a few of them, actually. I will say that even if they're smaller than our threshold, that just means we don't certify them or cite them. We do have what's called gas safety obligations for them after they're cited. So we know where they are, and they have to adhere to our rules, but we don't have anything to do with the citing or the certification initially. It's 100% between the landowner whose property the pipeline is being cited on and the pipeline company. And as I was talking about before, seeker also applies to those smaller lines. So if any state or local permit has to be issued, they have to go through seeker. So I don't want you to think that there's no environmental review on those smaller lines. I'm bouncing around here because this thing covers electric as well as gas, and we're here to talk about gas today. So we already talked about that. Let me talk a little bit about the process for the small, medium, and large. The 121A2s, the smalls, we call those a notice of intention, and that's in the law, an NOI. And that's the small one. An NOI is the bare bones minimum, the stripped down process. Basically, the company just has to tell us where it is and when they're going to build it and what they need it for. Those are the only three things they have to tell us. They only have to serve us, they only have to let us know, and the local governments that they cross. And the only thing the commission has to find to approve it is that it minimizes environmental impact, also that it's needed. Let me back up just a second. As I said before, I work for the Department of Public Service. People use DPS. People use that and Public Service Commission interchangeably. They're related, but they're not the same thing. The PSC, the Public Service Commission, are 5 members appointed by the governor and approved by the legislature, by the Senate. And they're the only ones in the building with a vote. The chairman of that group, the PSC, is appointed by the governor as well. And he's also the chief executive officer of the Department of Public Service. So he's the chairman of the PSC, and he's also my boss. The Department of Public Service is essentially staff to the PSC, but in many cases, and I'm going to get into this in a second, the PSC has to make the decision, and if the case is adjudicated, if it goes to a trial is what it comes down to, staff is just another witness. So we have to maintain very strict levels of separation between the decision makers and the expert testimony, the expert staff. So it is a very important distinction in that we're not the same thing, because if the commission is making a decision on something, we can't even talk to them about it. It goes through the judge makes a decision, and then that goes on to the commission. But I'll get into that in a second. As I said, I was on 121A2s, the notice of intents to small. All you got to do is, like I said, tell us where it is, what you need it for, and when you're going to build it. Those are the only 3 things. And the commission only has to find that it minimizes the environmental impact to the greatest extent practical, and that there's a need for the project. And the interesting thing is need is not defined in the law. And we'll get into that in a second. So it's what the commission determines is need. Now, I will tell you this law has been in effect since 1970, and there's an awful lot of case law and precedent as to what we have to have in order to find need. But it's not defined in the law, and it's going to get tricky in the future, and I'll explain later. The medium lines are called applications. So you have NOI is small, an application is a medium. And again, the medium is either greater than 6 inches in diameter or greater than 1,000 feet, but less than 10 miles in length. Along with the things that we need, that the applicant has to give us for the small lines, they have to give us quite a bit more. And let me just pull this up so I don't miss anything. Let's see, they have to give us the date they intend to begin construction, a statement describing the location of the line, where it is. Also, they have to give us something called approved environmental management and construction practices. They have to tell us how they're going to build it and not harm the environment. And there's two ways to go with that. They can use ours. We created our own, and it's been refined over time. The last heavy revision was in '96, but we're working on another one now. Or they can use their own. Now, some companies have come in with their own. Most companies tend not to, because our staff has to go through every single line of it and make sure it meets our standards. So if the company's in any hurry at all, it's to their benefit to use ours. And in the end, theirs are going to look an awful lot like ours, because we're going to require everything in theirs that's in ours. What else? They have to show also the location of any cultural or historic resources. They have to show that they're not going to impact them. I actually have a visual resource person on staff who has all the stuff loaded into a database, that there's an archaeological site or a park or even something as a golf course that might be impacted by this project. And as you can imagine, the visual impact post-construction for electric transmission line is probably a lot bigger than a gas line, because they're underground and they grass over them. They plan over them when they're done. So the visual impact is a lot smaller as a rule. The third and largest type, we just call it a full-blown Article 7. And Article 7 is basically anything that's over 10 miles long. And joking before, I said you see a lot of lines that are 124 PSI. You also see a lot of lines that are 9.8 miles long. So they work very hard to route them, to keep them as short as possible, to try and avoid going into the full process. Now, the full-blown Article 7, these are generally the bigger lines. Sharon talked about laser before. Laser is a line that goes from the Pennsylvania border, 9.8 miles, to the Millennium Line, okay? If it were 10.1 miles, it would have been a full-blown Article 7. But the line, oh, and by the way, we do verify the length of the line down to the foot. So another thing I'd say is you occasionally see people come in with a 9.8 mile line and then 2 years later try to come in with another 5 miles. We have what's called a rebuttable presumption, where basically if they do that, we assume they were doing it to circumvent Article 7 and we deny it. They have to rebut that presumption. They have to show, oh no, it was just an accident. It does happen occasionally. Not very often, but occasionally it does happen. Once you get into full-blown Article 7, it's basically an adjudicated case. You have a trial judge, an administrative law judge is appointed, and then there's parties to the proceeding, and staff, myself and my colleagues, are automatically parties to that. And then there's other automatic parties. Agriculture and the Department of Agriculture markets, if there's any ag land cross. DEC, the Department of Environmental Conservation, is always a party. Department of State is always a party. Other people can be parties as well. In fact, anyone can be a party. There's two ways you can participate, and there's pros and cons to both. Full-blown party status means that you're subject to negotiations. You get to participate in the negotiations. It also means that you get every shred of document that's exchanged. And if there's settlement negotiations, you're part of those. Where if the developer and the environmental groups and DEC want to come to an agreement instead of going to trial, that's the settlement negotiation. The flip side of that is there's obligations that go with it. One, you're subject to the direction of the judge. The ALJ can order you around. He can say you have to be here at this day. He can say you have to file something on this day. And then well, I'm trying to think of some other, you can see what I'm saying though. There's obligations and there's responsibilities that go with being a full party status. The second option is what we call an interested party. Any person can be an interested party. You don't get the benefits of being in the negotiations, but you get every single document. So you're aware of all the proceedings. You can come to the proceedings, although like I said, you're not eligible to participate in the negotiations. Party status used to be, interested party used to be kind of difficult for us because interested party got all the documents, and that meant we had to put it in a box and mail it to you. Thankfully, the modern age of computers made that a lot easier. If you agree, we can serve you electronically, so we can just email you the documents. So that makes it a lot easier for everyone. You don't get the boxes and boxes and boxes. In the old days, virtually all the full-blown Article 7s went to trial, and that meant that the applicant put in testimony saying this is where the line's going to be, et cetera, et cetera. These are all the impacts. The other parties would put in testimony saying we don't like where you're crossing this wetland, we don't like how you're crossing this stream, we don't like the impact from this historic, this old mansion. It would then go to a judge, just like Perry Mason. There'd be a judge up there, there'd be lawyers from both sides, and they'd submit testimony. The opposing judge, attorney would cross-examine, and at the end of that, the judge would make a decision. We call that the recommended decision. And the recommended decision then goes to the Public Service Commission, which can either approve it, deny it, or approve it with modifications, okay? That's, in the past, up until about 5 years ago, virtually every case we did went through that process. What we're seeing more and more of is settlement negotiations. It starts the same way. The parties meet with the judge, and then someone says, well, we'd like to see if we can work this out. And then all the parties basically meet every week for however long it takes and try to reach agreement on all the different points. They start by scoping, which means they list all the issues that are being debated, and then they try to resolve each of those scoped issues. And if they can resolve them, that's called a settlement, and the settlement goes to the ALJ, who then sends that up. Now, of all those issues I listed before, it could be that they only get 3/4 of them. There's a couple left. So they'd settle on most of it, and then they'd go to the trial phase again to work out those remaining issues. I can't say I've ever seen a case that made it all the way through where every single issue was resolved by settlement, but I have seen them come pretty close. It tends to be a better process because everyone is more involved. There's less, you can imagine a trial process can be sort of tension, there could be tension there. Where this process, people are working for a common settlement. So it tends to produce a better outcome. But I've never seen one get all the way through where 100% of the issues were settled and nothing had to be adjudicated. But it is nice because it greatly reduces the amount of things we have to adjudicate, and it shortens the process. I will say, people say, well, are we just a rubber stamp? Does the commission just approve every project that comes in? I can tell you absolutely not. What usually happens is if it makes it all the way through the process, it'll be approved or approved with modifications. The bad projects fall out before they get there. They withdraw. I don't know if this is an electric line, but many of you probably remember an electric line called the New York Regional Interconnect, NYRI. It never made it that far. They withdrew before they got that far. And that tends to be how it goes with the projects that don't have local support or have problems that just can't be overcome. So I'm not saying the commission doesn't deny things. I know for a fact they have. But by and large, if it makes it all the way through the process, the commission will probably approve or approve with modifications. There are a couple of exceptions to things that come to our jurisdiction. One is a line that's involved in interstate transport. Sharon mentioned the Millennium Line before. That connects different states. In fact, ultimately it connects different countries if you add it all up. That project was done by the Federal Energy Regulatory Commission, which the federal government, process substantially similar to ours, but it's federal, not state. Other projects that are exempt are projects that are located entirely under the streets of a city of 125,000 people or more. These are largely lines that are done to serve customers. So if you have a project that's in New York City, it's all underground, under the streets, it's exempt. I do know of one project where it was a 14-mile line. It came up to cross the Harlem River, and it crossed under the deck of a bridge. That was enough to throw it into Article 7. So that's all it takes to get it above. Other exceptions, that's pretty much it. I guess we're going to have questions later, but I very much appreciate your time. I will say, just very briefly about my staff, I have a very diverse and talented group of people who work with me. I have marine biologists. I have, as I said, visual impact. We've got a guy who's training to do noise impact because that's going to be a responsibility of ours. We have foresters. We have people from Syracuse ESF with environmental degrees. These people take their stewardship of the environment very seriously. And the other thing we take very seriously is the public process. I will say every single document for every case we review is on our website. It's a thing called Document and Matters Management, DMM. And DMM is great if you have the case number. It has a search function that will allow you to sort of search out the case number. But if you have the case number, it's an awful lot easier. Case number is 2 digits, it's the year. So right now we're in 12. And then a dash followed by a capital letter. For pipelines, they're all T, and T stands for transmission. And then a 4-digit number after that. And that's just chronological. So the first gas transmission line in 2012 would be 12-T-0001. And then they go up from there until we hit the next year. If you have that case number, it makes finding the documents an awful lot easier. Every public comment that was submitted, every single letter, every commission finding, every press release will be available if you just type in that case number. So I do urge you to go there. It's just our website. It's dps.ny.gov. It just changed. We're trying to make them all homogeneous. Got it. I very much appreciate your time. Sharon asked me to stick around to answer questions afterwards. And let me give you my name and email address. And if you have any questions in the future, give me a call. It's james.austin, AUSTIN, at dps.ny.gov. And my number is 518-473-4635. Thank you very much.
Thank you, Jim. Yes, we will be taking questions at the end once we've heard all the speakers.